Hello and welcome to another edition of the Flabota podcast, hosted by the Fort Lauderdale chapter of Abota. I am Flabota President Jeff Edelman, and today we have a guest who is very familiar with Flabota. In fact, she was the 2015 Flabota Jurist of the Year. She is the past administrative judge for the Civil Division of Miami-Dade County. Judge Jennifer Bailey, thank you so much for being with us today.
Thank you for inviting me. I'm delighted to be here.
Well, I want to thank, first of all, our producer, Mitch Chester, but I also want to thank our sponsor, Trilogy Trial Consultants. If you are interested in learning about more what they do, trilogytrial.com, unparalleled visual strategy and trial presentation. They do video, research, exhibits. Check them out for all of your trial needs. Well, Judge Bailey, I know that it's been a little bit since you retired from the Miami-Dade County bench after many decades. Tell us what you're doing these days.
Yeah, so I retired November 28th with the notion that December is always a wash anyways for most of us, and that it would give me some time to sort of figure out what I wanted to do because I'm lucky enough to have a lot of options. I've spent the last 15 years of my life not just serving as an administrative judge in Miami through an entire series of crises, but also working on a national level on civil justice improvement. I worked on the Civil Justice Initiative with the Conference of Chief Justices and State Court Administrators. And out of that came a lot of empirically supported recommendations on how to improve civil justice. Because, the bottom line, we all know it, it costs too much, it takes too long, and frequently the value of a case is distorted by process exploitation along the way, which needs to get shut down. People should be able to come to court with the problem, because everybody comes to court with a problem, and they have a pretty good idea how long it's going to take to get an answer, and more or less what it's going to cost to get that answer. And so my idea was when I retired is I would spend a couple of months just sort of sifting through options that are out there, which is what I've done. I'm doing private judging. I have my first big private trial. I'm doing the case management work now, and it's going to trial in November. I'm on the panels at the American Arbitration Association for construction, commercial, and international. Sitting in business court for the better part, I think it was 14 years, did a lot of construction work. And also along with that, had an opportunity to try some of the longer and more complex cases in the circuit. So I'm trying to take advantage of all that and offer help on cases wherever people need it. So yeah, it's going great. Thanks for those of you that have called me.
No, it sounds amazing, and you've always been very innovative and really at the cutting edge, trying to change the profession. I know that in 2020, you actually were involved in the first hybrid trial in Miami-Dade County. Can you talk about that?
Yes. So first of all, thanks to the Miami-Abota chapter. This was so my arc during COVID was the first job was to get everybody on Zoom, and I was put in charge of the training of all of our judges. And so we got everybody trained up, as you all know, very quickly. The other advantage that Miami had that other jurisdictions didn't have is because we already had Court Map up and we were functioning in this digital submission environment. On paperwork, we didn't miss a day of work. A lot of places completely shut down and you couldn't file your documents in the courthouse and the clerk wasn't processing paper and so on and so forth. But because of Court Map and our close work with then Clerk Reuven, we didn't miss a day on the paperwork. But the question that everybody was driven by, continues to be driven by, is trial dates remain the lodestar of how civil cases move. I have done my level best to peel all of you off of that because in truth, it doesn't work as an organizing principle because you're organizing around an event that truly rarely occurs. Trials across the country and locally occur in less than 3% of the cases. So to take a trial date and work backwards is much less efficient than starting consistent work through the life of the case to get it to the point that it's ready for either a full and fair neutral evaluation about whether or not it can settle or not, or go to trial, because that way you know what's going to go to trial or much more likely to go to trial, as opposed to being on a trial calendar with 50 other cases, 48 of which are going to settle, which is why, every time you all are on a trial calendar, it feels like such a juggle. But all to say, during COVID, with the loss of the trial date as the organizing principle, two important things happened. Number one is lawyers were fairly panic-stricken because there were lawyers that refused to do depositions. They said, we can't do discovery, COVID, all the things. That got solved by the recommendation from the work group on improved resolution of civil cases, which I was honored to serve on under Judge Morris of the Second, and Chief Justice Kennedy adopted the case management order, which I know created a lot of gnashing of teeth. But truthfully, everybody forgets that's really what kept cases going during COVID. If we hadn't had the CMO requirement, what would have happened is everybody would have started to get their cases ready for trial once we came out, which means we would have a lag time, as opposed to the minute we came out and we could safely hold trials again. Boom, Miami was trying cases left and right. We tried more cases the first year after COVID than we tried in any year that I was on the civil bench. The pilot case, though, was to try to test the concept with absolute safety of whether you could go to trial during COVID. This was pre-vaccine, summer of 2020. Flabota in Miami found us 2 volunteers to try a case. It was, a first-party property insurance case, so it wasn't enormously complicated. It was a case that could be tried in a brief amount of time. And it's weird to look back at it because so Judge Butchko tried the case. I managed the case in terms of the logistics and tried to make sure everybody was where and had all the materials and paraphernalia they need. But I mean, we had face shields, we had on masks, we had everybody social distance. We had rules about who could be where, and you had to stay by the podium. We had separate items for every juror: hand sanitizer, gloves, face shields, masks, legal pads, wipes to wipe off the legal pads. We had to deal with, how are you going to share evidence? We're going to wipe it off. Great tribute to the lawyers. We were able to successfully try that case, get it to a verdict. Everybody was safe. I mean, there was no COVID that came out of that case. And it at least demonstrated that 2 things. Number one is that Florida remained committed to the right to a jury trial, even during COVID, and that we were going to figure it out one way or another, even if we had to do one at a time. And secondly, that, typically it could be done, that it was possible to handle trials safely during COVID.
Well, I know that what you did definitely had an impact throughout the state and the nation, and it was wonderful watching you and Judge Tudor in Broward and Judge Marks in Palm Beach all kind of getting together, working together in the Tri-County area to try to at least get some normalcy to the civil justice system and criminal justice system too.
Well, I'll tell you, there are some real silver linings in COVID. And one of the silver linings post-COVID was during COVID, those of you that try cases in Miami-Dade know that we sort of went with this system that we call direct report, because typically you can get 300 people in our Miami-Dade 1925 courthouse jury pool. But with social distancing, it was 100 people, maybe not even that. Maybe it was more like 84 tops. And so, you don't want to put that many people together during COVID. So what we did was, once we were satisfied that we could open up, even though it was still social distancing and all that. In other words, once the case rates went down. And let me just call out, because I would be remiss if I didn't do this. The Florida Miami chapter created a task force to help us do this, and had fantastic doctors, a public health expert, Dr. Zinzi Bailey, Dr. Hansel Tooks from the University of Miami, and Dr. Ratson, Stuart Ratson's dad, who is an extraordinary specialist, gave us guidance about all the medical information to make sure that we were operating safely. But this direct report, what we would do was we would have people directly report to the courthouse, to the courtroom in the courthouse, instead of going to the jury pool. So you're bringing fewer people together, and you could bring them in waves so that you could preserve social distancing. And it worked. But the great thing about that was after COVID, we kept a two-method jury pool. So we always filled the jury pool every Monday. But we also, in the really huge cases, had direct report. So for you, those of you that tried, med mal or tobacco or any of the big product cases, we would have 150 jurors report. This is post-COVID at 9, or 75. We'd have another 75 report at 11. We'd have another 75 report at 1. We'd have another 75 report at 3. And you'd get through all the hardships. And the beauty of that is that would take a substantial portion of the jury pool on a regular day. Well, not anymore, because you're not putting them in the jury pool. So you could still keep all the regular trials going. And this made us so much more efficient, because in all the big trials, you weren't constrained by the size of the jury pool. You could push out panels left and right. And so there were days in 2022 and 2023 where we had 1,000 jurors showing up on a Monday. But it didn't feel like that because they were going all over the place. So it gave us some tremendous advantages in terms of making sure that trials could get going, move efficiently, and people weren't sitting around waiting for a panel or weren't waiting around for throwbacks.
It sounds like it's a lot more efficient and allows a larger pool for attorneys to select a jury. So that is definitely a plus for sure. Well, let me ask you this, Judge Bailey, because one of the reasons I really wanted to talk to you was you were interviewed in the Daily Business Review around the end of last year, and you talked about a problem in the legal profession. You termed it the graying of the bar. Can you talk a little bit about what you meant by that comment?
Well, when I talk to my colleagues, it's fairly apparent that there are not as many lawyers with trial experience as there used to be. And those that have trial experience are now senior partners and senior lawyers, the back end of the baby boom, as it was. And it's much more difficult for young lawyers to get trial experience. And as a result, there is, I think, two things. Number one, a lack of confidence on the part of individuals about going to trial. And number two, a lack of confidence on the part of clients about having younger lawyers take their cases to trial. So by way of example, when I was a young lawyer, the first year I was practicing in Miami, I was with a large old Miami firm that's now substantially gone, as many of them are. But my first year, we had a automobile insurance defense client who wrote 10, 20 policies. And I must have tried, I don't know, somewhere between 10 and 15 rear-end automobile accidents. They're all soft tissue. And I tried them. And after the first 2 or 3, I tried them by myself as sole lawyer, because the exposure was limited. So The firm could afford that opportunity. The insurance company didn't want to pay for 2 lawyers. They wanted a cheap baby lawyer. And so you could get a lot of trial experience. It's one thing to read the rules of evidence, even if you got an A in your evidence class. It's another thing to be able to think about them and apply them on your feet in the courtroom and to make the proper objections and to, more importantly, learn how to listen to the testimony coming from the witness stand. Because lawyers that are less comfortable in trial have a legal pad. It's got a list of questions on it. They are tied to that legal pad, and the witness can be sitting there and give you the absolute home run answer to the question. I mean, I'm sitting there listening to it as judge going, okay, there's the DV. And the lawyer doesn't even hear it because he's not listening to the answer, or she. They're thinking about what their next question is. That facility with being able to actively listen is also, I think, being shortchanged. So the question then becomes, you can plan all the battle strategy you want, but being in war is a much different experience. How do we get folks the kind of experience that qualifies, frankly, people to be in an institution like Abota, which is trial lawyers?
Sure.
And that's a challenging question. There is, I think, a couple of different ideas. One really obvious one is this. There is a huge number of people. We have a huge access to justice problem. And yet we have lawyers that don't have enough experience. And most of the access to justice problem is in the kind of cases that lawyers don't see as particularly remunerative, but are really important problems to the people who are affected by those problems. And there may be some opportunities for lawyers to say, I'm going to take on some lost leader cases, or I'm going to take on some lost leader clients, or I'm going to take an insurance client and offer them the deal of the century with the understanding that I'm going to put my young folks on this so we can get them trained up on trying cases. The access to justice issue might also be susceptible to solution by working with legal services or legal aid or some of the other pro bono organizations to say, look, we'll take cases to trial. We're not going to work them all up. You guys call us when you're getting close to trial and we'll take them to trial. But I think people to do that have to think outside of 2 narrow boxes. Box 1 is the money box, right? Because they're not going to make you a ton of money. They're just going to make you a ton of experience. And you have to make the determination that the investment in personnel is worth that. That's a challenge in this day and age because there's not the same kind of institutional loyalty where people went with a firm and stayed with a firm forever. But, Abota has always stood on first principles, right? That they want to preserve the right to trial by jury. And the right to trial by jury is best preserved by having lawyers that know how to try a case to a jury. So it may just be an investment in the system going forward.
Yeah, and if you have a young, talented lawyer in your firm, bring them with you, have them do a few things during the trial and start, grooming them along.
Well, and training them, because that's the
Right.
second box. The second box is you have to invest your own time and effort and convince the clients to invest their time and effort into training people. I mean, I got to tell you, as a judge, it was really always pretty obvious, whether you were on Zoom or live, when you had a senior lawyer arguing a really important motion that a young lawyer had done all the work on. Because that young lawyer knew everything about that. Could have argued it, bing, bing, bing. The senior partner didn't know it as well. And while they were smooth in their presentation, had a lot more struggle answering questions or dealing with nuance if those kinds of questions came from the bench. Now you're going to know in advance what kind of judge you've got, whether that's going to be a judge that's a hot bench or whatever. But the truth of the matter is that that's a missed opportunity on both sides. The challenge with clients is when clients wait a long time for a hearing, or it's a significant hearing, they want what they perceive to be the head man, head person in there arguing, which may not be the best thing for their case. It might be the person that knows the most about it that sat through all the depots. And so that's an important principle that also needs to be conveyed. The clients need to trust the lawyers, and the lawyers need to be able to pick out the right person to argue. And that the subsidiary is, look, we all became litigators because it's fun. And with hearings becoming rarer, and particularly live hearings and trials becoming exceptionally rare, I can understand why senior lawyers want to do it because it's fun. We love, by and large, we love our work. All of those have to be juggled to try and determine how we're going to bring the next generation along.
Well, do you have any other suggestions that maybe firms can do to try and get people more experience so that we stem the tide a little bit?
Well, I think, like, as you say, bringing people to court with you as much as possible. If a lawyer has some downtime with the amount of work that's currently being streamed, watch what's going on. I mean, one of the things that folks have talked to me about as being a downside of motion calendars being on Zoom is when it was live, you'd sit in that courtroom and you would get educated while you sat through motion calendar. That doesn't, the sense of it is that doesn't happen the same way now because people show up at a specific time for a specific hearing. That's a double-edged sword, right? So one of my arguments on the civil justice improvements is, look, you can't make people come down to court for motion calendar anymore. You can't take lawyers that cost a couple $100 an hour, make them get in their car, sit in traffic on US 1 or I-95 to come down to court, to sit there for an hour with, 50 other people, for you to talk to them for 5 minutes and then do the whole thing in reverse. It makes motion calendar a $1,000 proposition, and the return on that investment does not justify that for most clients, as opposed to being able to get them on Zoom. So, but all to say, the 11th Circuit's hearings are on a public listed webpage. It says, here's all the hearings for Judge Bailey or Judge Thomas or Judge Simon or Judge Walsh today. You can go in there and watch. They're open. And I think you can get much of the same kind of education that you get what you got live. What you don't get live is the hanging out education.
Yeah,
And that, yeah, go ahead.
I do miss that part. I don't miss the
Yeah.
drive to the courthouse, but I do miss seeing people from other cases, checking in on them.
Yeah.
Talking about other cases. And that's something that it's not coming back. I don't think it can, but it definitely makes me reminisce a little bit on that.
It does. And, my acerbic take on that is, really, we shouldn't be in the business of arranging play dates for lawyers, but that's really unfair. I just want to acknowledge that.
It's a funny way to put it, but it's true.
It is, because what would happen is you'd see somebody there that you had another case with, and you both finish your motions, then you go get a cup of coffee and settle your third case, right? That wasn't even on the calendar. But, I think the pendulum may, with some effort, be swung back. It will take effort. I mean, the truth of the matter is that we've all grown increasingly isolated. We rely on this, what we're doing. We email as opposed to pick up the phone. I mean, look, there is a lot of communication that gets lost in email. aside from the fact that people will say things in email that they will never say to your face, the simple truth is there's a theory called it has to do with media rich communication, right? So email, all you see is the words on a page, right? But if I'm talking to you face to face in person, that's the most media rich, because you can see you can hear my inflection, you can see my expression, you can see my body language, you can see all the things which probably dictate that jury trials will always remain live. The least media rich form of communication, quite frankly, is, email, like written word. I mean, watch Hamilton when they're writing the letters back. Yours respectfully, A. Burr, A. Hamilton. Everybody's missing the point. So I think that some effort could be given to pick up the phone and call opposing counsel and say, look, I know we haven't met each other. Go get a cup of coffee after a depo, or if it's live. If not, just make an appointment to go get a cup of coffee. Say, look, we have this case together. It's a big case. We're going to be together for the next year and a half. I'd just like to sit down and say hello and see, what we can do to get to know each other to make sure we can work smoothly through this case. I mean, that just doesn't even occur to people.
And you're going to see these people again and again.
Yeah. And it's worth the investment, and it's worth the investment for young lawyers. I mean, this is part of the trial skills that operate outside the courtroom, which is, it helps if you know who you're dealing with. It helps if you have, even if you don't know them from before, if you make an effort to make some kind of relationship with them other than just sending emails back and forth. And frankly, the emails in a lot of Abota level cases aren't even between the lawyers. They're between the paralegals, who make it a point to talk to each other because they know that they're where the rubber meets the road, and they're going to have to talk to each other and deal with each other all the time.
Very true. Very true. Well, let me ask you this, because and again, I greatly appreciate your time. I guess what are the things that that you miss, and what don't you miss from your time on the bench?
I don't miss the traffic. I don't miss, I mean, I drove to the courthouse every day. And even during COVID, I was at the courthouse every day because it was the Miami-Dade courthouse, right? I never knew it was going to fall apart when nobody was there. So, I do not miss that. Although the creepiest moments in my life were when I'm driving to the courthouse at, 8:30 in the morning and the streets are just empty because of COVID. I miss the lawyers. I miss the community. I miss my colleagues. I really have, like I said, I am all over the country on civil justice improvement. And I remain convinced that Miami has one of the best bars. I mean, look, we'll go to the mattress on a tough matter, right? There's no question. Our lawyers know how to litigate, but really excellent lawyers who genuinely care about the delivery of justice in our community. And other than that, it was just time for a new adventure. We all know judges that stay too long, that you get in front of them and you're treated like their time is more important than your problem. And I never wanted to be like that. I left while I still loved my job. That's part of the reason why I'm doing private judging and arbitration, because it's a lot like my old job. And I'm continuing to do court consulting to try and help judges improve courts all over the country. I'm on a webinar for Washington State tomorrow. I was just in Indiana, and that's a lot of fun. So I'm having a great time.
Well, that's wonderful to hear. And I know that throughout your career, you've been involved with the judicial colleges and teaching other judges. And I guess for anybody who's listening or watching to this, who's considering maybe becoming a judge one day, what kind of advice could you give them?
Well, the election advice I always gave everybody was to buy the Crawl on the Weather Channel. because the primary is always at the end of August, and there's always like 8 storms piled up in in the tropics, and the crawl on the Weather Channel was really cheap back in the days when cable was dominant. So I'm not sure that's good advice in streaming anymore, but that was always my advice: buy the crawl on the Weather Channel. But I think those who are interested in running for judge need to understand this. There was a day, being a judge is like everything else. It's going to be what you make it. There was a day when being a judge, back probably when I went on the bench in 1993, was a little bit more of a slower and deliberate paced job. It is not anymore. It is a lot of work. You all see it in court map. You see orders signed. And if you look at that timestamp, judges are signing orders at 8 at night and 6 in the morning sometimes. The work is pretty relentless in a community the size of Miami. So don't take this job thinking that it's less demanding than practice, because it isn't, time-wise. And in some ways, it's more demanding because people come to court because a bad thing happened. They have a problem that you need to solve or offer a resolution to, whether that's through jury trial or summary judgment or motion practice or bench trial. You're responsible for solving that problem within a reasonable amount of time, according to the substantive law of the state of Florida. And so it is a big responsibility and can never just be another day at the office, no matter how long you've been doing it. So we have a great bench. People are really dedicated to the work, and we have great lawyers. So I am confident about the future of civil justice in Florida, across Florida.
Well, again, thank you so much, Judge Bailey. I hope that we'll see you maybe over the summer at the Flabota convention. It's July 25th through 27th, and at the Boca Raton Marriott, www.flabota.org for anybody who's interested. You can reserve now. For everybody at Flabota, on behalf of my producer, Mitch Chester, our sponsor, Trilogy Trial Consultants, and the Fort Lauderdale chapter of Abota, I'm Jeff Edelman. See you next time.